Welcome to the Lawyers Committee for Better Housing call-in show. Today we're going to be talking about security deposits. My name is Lacey Burpee. I'm a staff attorney with Lawyers Committee for Better Housing, and I'm here with our legal director, Mark Swartz. And on the phones today is Michael Stumpf, our AmeriCorps Vista. All right, so welcome, Mark.
Thank you.
So today we're talking about security deposits.
Yes, security deposits. Lawyers Committee for Better Housing mostly works with tenants who are facing eviction or otherwise facing the loss of their home due to foreclosure or constructive lockout, utility shutoffs, all those things. Just the emergency things that we really need to be dealing with. But we get a lot of calls about security deposits because security deposits are really important to tenants, especially low-income tenants who are waiting for that security deposit so they can move on to their next place. And to them, it's very important. So we thought we'd have this show and answer any questions that people have about it. Also, security deposit law can be a little confusing, and we want to answer questions not just to tenants, but to landlords, because we want landlords to follow the laws related to security deposits because it'll be better for them and better for tenants.
Yeah, so please call in with your questions. The number's at the bottom of the screen, 312-738-1060. We'd love to take your calls. So let's start with kind of the basics. So there are a couple different laws that may apply. Do you want to talk about when the city law applies and when you're with the state law and a little bit of the differences between the protections in those two?
Sure, I'd be happy to. Well, we're going to be doing this we're here every Friday, and we're going to be talking about when the city law applies and when it doesn't almost every week, because that's so important. People who are listening to the show need to know whether they fall under the Chicago Residential Landlord Tenants Ordinance or whether they don't. And anybody who's renting in the city of Chicago probably falls under the Residential Landlord Tenant Ordinance unless they're living in a smaller building that's landlord occupied. So, for instance, if I'm living in a building that's less than, 6 units or less. Is it 6 units or less?
6 units or less.
6 units or less. I always get this mixed up. 6 units or less, and my landlord lives there, then I'm not covered under the Residential Landlord Tenant Ordinance. And if I live in a building that's any number of units, could be a condominium, it could be a single family home, it could be a 3-flat, a 4-flat, 5-flat. If my landlord doesn't live there, I'm covered under the RLTO. My landlord could also live there, but it could be over 6 units, then I'm covered under the RLTO. If you're covered under the RLTO, then slightly different laws apply. It doesn't mean that if you're not covered under the RLTO that you're not entitled to the return of your security deposit when you move. It just means that that's all you're entitled to under contract. The lease is a contract, and you're entitled to the return of your security deposit if you comply with the lease.
And it looks like we might have a caller.
Okay, so we're going to put a check on that when we're going to take this caller, and then I'll tell you what different and heightened benefits apply to tenants who are covered under the RLTO with security deposits when we come back. So what's the call?
I just had to touch on this in terms of dealing with security deposit. There are some places, a few, and it's maybe a little bit rare, that some landlords are pretty good, depending on how big the building is, where you leave a security deposit where your money does earn a little bit of interest. You may want to consider that sort of stuff when you leaving a security deposit at different places.
Sure. Is that your question?
Security deposit. No, that's a comment.
Okay. Well, I completely agree. The security deposit, the security deposit does accrue interest. Now, if if you're living in the city and you're covered under, in the city of Chicago and you're covered under the Residential Landlord Tenant Ordinance, if the landlord doesn't pay interest, then there's some hefty penalties that attach. It can be a little peculiar in this day and age where the interest is really small. But, back when interest was greater, tenants who lived in a place for several years were entitled to $10, $20, $30, a year, depending upon what the amount of their security deposit is, and they weren't getting their interest. So one of the things that the Residential Landlord Tenant Ordinance did was protect tenants by creating double damage provisions for tenants to recover double their security deposit if the landlord didn't pay them their interest. In this economy, in this day and age, the interest is really tiny, but absolutely you're entitled to your interest if you're under the Residential Landlord Tenant Ordinance. If you're not under the Residential Landlord Tenant Ordinance, you're probably just entitled to get your security deposit back, unless your lease, as the contract states, that you're entitled to get interest.
Great, and it looks like we have another caller.
I'm telling you, security deposits are interesting to people.
Hi, you're on the air. What's your question?
Hi, my question is I'm going on the last month of rent, and I heard that I could just let my security deposit cover it, and I didn't have to pay that. Is that accurate?
That's a great question.
Yes, it's a question that comes up all the time. And the answer, unfortunately, is no, it's not accurate. You're not entitled to apply your security deposit to the last month's rent. However, it is not uncommon that people do that. And if your landlord agrees to allow you to apply your security deposit for your last month's rent, then I would get it in writing. Because if the landlord agrees to it, then that's fine. It's a perfectly fine way to handle the situation. The danger is whether your landlord agrees orally or whether you choose to do it because you're afraid you're not going to get your security deposit back. The landlord is entitled to file an eviction action against you if he gives you, let's say, you don't pay your rent, and the landlord gives you a 5-day notice. After that 5 days expires, because you chose to apply your security deposit to the last month's rent, you could find yourself in eviction court. And being in eviction court is not a fun place to be, even if you know that you're going to leave before an order of possession is entered, because you know that it's your last month. Because the problem is you now have an eviction on your record, and probably an eviction that was properly brought, and you might find down the line that that's going to impact your ability to re-rent in the future. So short answer, we do not recommend applying your security deposit to the last month's rent unless it is agreed to and you get the agreement in writing.
And I think that also brings up an important point of just trying to get, everything in writing. If you make any agreements with your landlord after you sign the lease, make sure that it's in writing, not just a phone conversation. Just getting anything you can in writing is really, really helpful just across the board.
That's true. Now, it brings up a good point, because why would the caller want to, use her security deposit as last month's rent? Well, because the caller is worried. The caller's worried that maybe the landlord isn't going to return her security deposit. And that may or may not be a proper worry. The landlord is entitled to take the security and apply it to unpaid rent and damages that might have occurred on the apartment that are more than, damages. It doesn't include normal wear and tear. So when you leave an apartment, anything that's normal wear and tear, maybe the walls are a little dirty or scuffed up, you've lived there a while, maybe the carpet needs to, maybe it's old, it's an older carpet. The landlord doesn't get to come in and say, I'm going to, redo everything, because this is considered, what normally happens when somebody, reasonably lives in an apartment for a year or 2 years or however long people are living there. So what the caller is doing by applying the security deposit to the last month's rent is assuming that all the landlord is entitled to apply the security deposit to is last month's rent. However, what if there are other damages? Then the landlord doesn't have security to go after to apply to fix the problems beyond normal wear and tear. So from the landlord's perspective, that's why they don't want you to apply the last month's rent. From the tenant's perspective, we understand why you do it. There's a very peculiar timing that occurs with the security deposit return in the city of Chicago as well, because tenants think, I don't have extra money to apply to a security deposit. I need my old security deposit to give to the new landlord so that I can have a security deposit where I go into my next place. Problem is, under the law, the landlord has 45 days to return your security deposit. So the tenant is in a bit of a pickle, and hard decisions sometimes have to be made. But again, to reiterate, if you don't pay your last month's rent and you say, I'm applying my security deposit to it, and your landlord gives you a 5-day notice and you don't cure within the 5 days, the landlord is entitled to file an eviction action. It doesn't mean that the landlord will, but if the landlord does, we don't recommend that, because we know how detrimental it is to have an eviction filing on your record.
And you mentioned normal wear and tear earlier. What happens when if the landlord goes into your unit and does want to take money out of your security deposit? What's the process? What are they supposed to do then? Are they supposed to let you know?
Okay. Well, if the landlord wants to apply any of your security deposit to damages, and again, this is if you're covered under the Chicago Residential Landlord Tenant Ordinance, the landlord needs to, within 30 days, advise you that they're going to be deducting this. And depending upon whether or not they fix the problems within those 30 days, they're supposed to give you paid receipts, attach these receipts, other indicia that they've actually paid to fix these damages. And if they don't do that, they're in violation of the residential landlord-tenant ordinance. If they haven't fixed it within the 30 days, I think as long as the landlord notices the tenant that in fact they're going to be reducing, I think there's an additional amount of time for them to get the actual receipts. And at that point, the landlord is allowed to reduce the return of the security deposit by the amount to cover the damages. However, once that 45-day window expires, the landlord is to return all the security deposit except for whatever has been applied properly to those damages. So 45 days.
All right. So let's take a moment and just put up a couple numbers. If somebody's having an issue with this, I want to make sure that we get these numbers up so people can see, some different organizations they can contact for help if they need more assistance with this. Let's get those up there.
Okay.
So the first organization is MTO. It's the Metropolitan Tenants Organization. You can call their hotline. And they're a community organization, so they're not attorneys, but they can help, talk to you about what your rights are and, help you maybe write a demand letter for your security deposit back.
Sure.
The Carpos hotline is down there. That's a legal aid referral hotline. So if you're looking for an attorney to help you with this, or you just want to speak with an attorney about your security deposit issue, or really, they do a wide array of legal issues. It's a great resource. You can call their hotline. Another great resource that we have is Illinois Legal Aid online, and you can go on their website and they have sample letters that you can write to the landlord. They have a lot of information, frequently asked questions. And if you're looking for, if you have to go to court and sue your landlord for the return of your security deposit, we've also included the Chicago Bar Association referral service. And their number is there in case you need a private attorney. A lot of private attorneys like these cases because, at least under the city law, they can sometimes get attorney's fees. So that can be a good incentive.
Oh, that's a very good point.
For a private attorney, that if you couldn't, some of them will take them,
Right.
if you, where they wouldn't take smaller cases otherwise.
So the thing about the residential landlord-tenant ordinance, which Lacey refers to as the city law, is that the city law has a fee-shifting provision for attorneys, because the city understood when they passed the residential landlord-tenant ordinance that tenants weren't normally suing for the return of the security deposit. They certainly weren't suing for the return of a tiny amount of interest, and yet overall millions upon millions of dollars were being lost because landlords just felt, many landlords, not all landlords, but some landlords felt that if they're not going to be sued, they don't have to return the security deposit. If they're not going to be sued, they don't have to keep track of interest. So the penalty for any violation of the security deposit in Chicago, if you fall under the residential landlord-tenant ordinance, is double the security deposit, which can be somewhat significant depending upon how much your security deposit is, plus the prevailing plaintiff gets his attorney's fees covered, which means there are a lot of attorneys in the city that are willing to take a case knowing that if it's a good case, at the very end they'll be able to get an award for the time that they had to put into the case.
Great. So do you have any general tips for someone who is moving out and they're worried about whether or not they're going to get their security deposit back? What can you do when you're moving in? What can you do to really protect yourself?
Sure. Well, security deposits really overlap with almost all the other areas of landlord-tenant law that we work at Lawyers Committee for Better Housing. So when you move into an apartment, this goes back to our recommendation that you have a check-in list. We recommend that landlords have a check-in list, and you can find these online. And what happens is the landlord and the tenant will walk through the apartment together, and they'll check off problems with the apartment. The landlord gets to know what's there from the old occupant, and for the tenant's side, they'll be able to know that their landlord's on notice about problems so they can maybe be fixed, and also that the tenant isn't going to be held responsible. Then at the end of the process, as you're moving out, you should have a copy of the move-in sheet. Your landlord should have a copy of the move-in sheet, and you both walk around together and you check again. And I think you'll find that there are probably only a few areas where people probably are going to disagree. And if they agree to disagree, If they agree to disagree, then then it becomes an issue. But most people, when they understand, the kinds of violations that can occur with the residential landlord-tenant ordinance if the tenant decides to sue, probably just decide, well, why is it worth arguing about this? And hopefully maybe the parties can, agree to some sort of payment, or the landlord will decide, I'm willing to consider this, the cost of doing business, normal wear and tear, and be done with it. But it's all about the parties being on the same page.
Great. It looks like we have another caller.
Yeah.
Hi, welcome. What's your question?
Yeah, I'd like to know why there is no resources for the landlord. I'm a landlord. I have
Sure.
a 3-flat building in Chicago.
Okay.
So I'm not getting rich off of that. I don't have, lots of money. So if the tenant doesn't pay me, then I totally lose.
Right.
They can go and get free legal help. I have to spend thousands or hundreds to thousands of dollars just to take them to court, just to get some justice. I think that's unfair that the way the law is written. It should be equal.
Well, the city has a great resource. It's called Chicago Rents Right, that does have resources for landlords, and it helps landlords comply with the RLTO, and gives guidance to make sure that you can protect your interests that way. Do you know of other organizations that?
Yes, well, the same website that we gave for tenants,
Oh, right.
the Illinois Legal Aid Online, is an incredible resource for landlords. So you look on there, and if you type in any keywords or questions, it'll bring you to pages that will help you provide sample 5-day notices if you need to notice that a tenant isn't paying the rent, in order to demand the rent so that you can evict the tenant if you have to, and a lot of other resources. I do want to acknowledge, your concern that landlords aren't getting the same kind of free legal services that you see tenants getting, and really most people aren't receiving the legal assistance that they need in Chicago and in Cook County. There are about 31,000 eviction filings, and the vast majority of tenants are unrepresented. There are more landlords represented, certainly, but we really understand that it's hard not to have legal advice and to have to go into the courts on either side, whether you're a landlord or tenant. I really think that Illinois Legal Aid Online is trying to help and level the playing field. I would argue, though, as a tenant advocate, that the residential landlord-tenant ordinance levels the playing field for tenants, because prior to that ordinance, landlords, not like yourself, it sounds like you're responsible and are concerned about following the laws because you don't want to get into trouble and you don't want to incur expenses. And you're not, as long as you're living in the building anyway, it's not an RLTO building. But it was determined that people were not returning security deposits or paying interest because nobody was willing to go to court on behalf of tenants because it just wasn't enough. It wasn't worth enough. And that's why they added the penalties. But there's one easy way to avoid all of the residential landlord-tenant penalties, and that's just to follow the law. And I want to put a plug in here because at some point, maybe we'll have a show for landlord call-ins, but we would like to, as part of the show, be a resource for landlords. And that's why, even though you said you were a landlord, we took your call, and we're happy to answer any questions for landlords because we want everybody to understand how to follow the laws because we think that it's best for everybody.
Great. Thank you so much for your question.
Thank you.
We have another call. Hi, what's your question?
Hi. Can you hear me?
Yes.
Yep.
Okay, I paid a $500 move-in fee when I first moved to my apartment 2 years ago. So shouldn't my landlord be paying me interest on it?
Okay, move-in fees. That is a big issue.
That's a good question.
That is a good question. Whoa. Well, because of, I'm going to refer back to the landlord caller, because certain landlords were, felt that it was more difficult to follow the law than it was worth. A lot of landlords decided in the city of Chicago, look, we're not going to take security deposits anymore. We don't know how to handle them. And I think that's an incredible shame because security deposits are there to protect the landlord so they don't have to sue the tenant, down the line for unpaid rent or damages to the apartment. So it's a very good mechanism for protecting landlord interest. And it's good for tenants too because the the alternative isn't, and the alternative is move-in fees. The problem is landlords who don't want to take security deposits from tenants are taking move-in fees, and the move-in fee is non-refundable, which is bad for tenants because the tenant is now paying something that's almost a security deposit. I mean, $500 is close to what a security deposit would be for somebody with a, let's say you're paying $800, usually a security deposit's $800. So a $500 move-in fee that's non-refundable, while it's not a security deposit right now, is not benefiting the tenant. And I don't think it's benefiting the landlord either, because it's not enough. And it's sort of a way to almost hide the actual amount of the rent, because what they're really doing is they're charging an upfront fee rather than, saying, well, instead of the rent being $800 a month, it's really $825. They're charging you this $500 fee that you're not going to get back. At some point, somebody might, come and say that actually that's consumer fraud. If you're taking a $500 fee, it should be spread out, across the months. Or somebody's going to take the position that no, a move-in fee that isn't attached to actual costs, administrative costs or otherwise, if you live in a high-rise building and there's a cost to actually, reserving the elevator or having a space where, somebody can help you use the freight elevator and that's going to cost money. A move-in fee that's not attached to actual costs could be attacked as being a security deposit by some attorney, maybe me, maybe some other clever attorney. But the short answer is move-in fees are not security deposits. And because they're not security deposits, until the law is clarified, I don't think that you're entitled to interest on that, nor are you entitled to the return of it at the end of the lease. I'll tell you one other thing about security deposits. The law, the case law out there pretty much says it doesn't matter what you call a security deposit. If it's a security deposit, it's a security deposit. And so a move-in fee that is refundable, but but that the landlord might be able to take money out of for damages or unpaid rent, is a security deposit. It doesn't matter what the landlord calls it. But if the move-in fee is non-refundable, it's not a security deposit, at least right now. I'm not going to tell you it is, but I think you could argue it is. It's not a security deposit. You're not entitled to the return of it, and you're not entitled to interest. Bad for tenants and bad for landlords, I would say.
I mean, they seem like such a good deal because they're usually a little bit cheaper, but in the long run, you're not getting it back, and like you said, the landlord doesn't have as much to recoup from if there is a problem later.
That's right.
So we are. Is there anything you wanted to touch on that we haven't talked about yet? We just have a couple minutes left.
Okay. Well, I could go on forever about security deposits, and if there's more interest, we'll do them in weeks to come. But some interesting things about security deposits that people might not know is in the city of Chicago. This is since 2010. If you are living in a building in foreclosure and the building is acquired by a bank or anybody, if the building is acquired by anybody after the foreclosure goes through to final judgment, the new owner in the city of Chicago, at least, is responsible for the return of the security deposit. And that can be strange because oftentimes it's clear that the new owner probably didn't get the security deposit from the old owner. And yet, in the city of Chicago, if you buy a property in foreclosure, you'd better be aware that you have to return the security deposit to tenants. And that's great news for tenants, because what we were seeing in the past is that foreclosure victimized tenants who were, because the landlord just walked away with their security deposit. And it was a great loss for tenants, because many tenants who are low income need a security deposit so that they can move.
And for anybody interested, I'm going to put up the overhead again. For anybody interested in more information about, buildings that have gone into foreclosure or tenants that are living in them, next week we are having one of our senior attorney in the Tenants in Foreclosure Project on to talk about tenants in foreclosure. On October 25th, we are having the Center for Conflict Resolution come to talk about negotiating with your landlord and mediation. And on the 1st, we are talking about the new Chicago law, the Chicago Protecting Tenants in Foreclosed Properties Ordinance, also known as the Keep Chicago Renting Ordinance, with our special guest, Albany Park Neighborhood Council. So there's going to be a lot more information for tenants who are in foreclosed buildings. And just really quickly, for anyone that's interested, there's a rental housing expo from 9 a.m. to 2 p.m. at Loyola University on October 26th.
And we'll be there. And if you want to go one-on-one and talk to attorneys and other housing advocates, they'll be there and you can ask them any questions you have.
Great. It looks like we're out of time, but we will see you next week. And if you have any questions about tenants in foreclosed buildings, please give us a call next week. Thank you.
Thank you.